May it please your lordships.
Pass on the memo. And if the admission will be over, then it will reflect, my lord. So this may be taken up next week, my lord.
Yes, pass on.
Then the vote today, item number 27, may be permitted to withdraw with liberty to close the appropriate vote.
Other side.
The residential house of the petitioner applicant, my lord, going to be demolished after 30th, any time after 30th. I pay for 30th, my lord.
Give pass on.
May it please your lordships me.
Yes.
Lord, we mentioned yesterday, your lordship, to recollect, Lord, the appointment of the GST tribunal members headed by the Honorable Supreme Court sitting judge. Lord, the matter is coming, but it's item 38, the last item in the list, and we understand afternoon there's no.
Yes, I will. Mr.
Lord, kindly share the matter.
From the other side also, please.
We will from the other side. We will from the other side.
Lordship, I want to mention, my lord, it is an elephant corridor matter, my lord. I have submitted the memo through the registries.
One minute, counsel. I'm on my legs mentioning before 1 minute.
Yes, yes, we'll take up the matter. Don't worry about it.
Extremely okay.
Is it possible to?
Let us see. We'll take up.
Lordship, it is a elephant corridor matter. There is a direction of the Honorable High Court to the Chief Secretary and the Government of Orissa to formulate a task force. On that, the order is of the years back. Lordship, this matter may kindly be taken up. I have submitted the memo.
Yes. Please pass on the memo. We'll take up. Don't worry. Please pass on all the memo. Pass on. It will be. Don't worry.
Item 29.
Yes, please. Yes. Call the list.
For judgment, item number 1, WA 852 of 2025.
The result is Reconstituted Sans Merit is dismissed, confirming the judgment dated 25/4/2025, rendered in WPC number 40116 of 2023, and all pending interlocutory applications shall be stand disposed of. No order. I propose.
You that paragraph you will see.
Item number 2.
Working at a plot, he was in charge of compliance section. We tried for the report of article section. During that period, 5 sections now were missing. Landlord's briefs were discovered in front of the house of land area gate, and 2 of the briefs were reconstituted, trial were done, and all the cases have been disposed of. However, subsequently, departmental proceeding was initiated against the petitioner. I have demonstrated whether the member of charges and your CBC annexes 4 at page 32. Against 3 persons, the proceeding was initiated against bench clerk, the peon, and this person was working in the compliance sector. Now, during the course of the inquiry, though there was a lot of violation in the matter of not providing the document. The most important violation in the case is that the order by the disciplinary authority has been passed on, the lordship will find, on 1/9/2021. Whereas the inquiry report has been provided to me on 13/12/2021. That is after the punishment has been reflected on 25/9/2021 at page 129, accepting the inquiry report. But the inquiry report has been supplied to me post facto the imposition of the punishment on 13/12/2021. I preferred an appeal before the appeal committee. I took specific ground that the inquiry report has not been supplied to me along with the materials. However, my appeal has been dismissed. The lordship will find that page 151, and that is how I am before your lordship.
Yes, what you have to say,
My grievance is your lordship, see,
the other side.
129 the disciplinary authority simply accepted it out without analyzing anything. Take a fresh
Committee of this for the report.
Two increments without cumulative. That is, he says that the report, the query report was not sufficient.
You produce the record, you verify first the record, whether inquiry report has been supplied and his petitions have been disposed of or taken note of or care of. It seems he has given a
time permission. I say that the punishment was imposed first, report was supplied much earlier. This is
No, you applied also subsequently, sir.
it should have been supplied only
Sir,
not me
but
applying
you
it.
made an application only after the appellate court's
And that
order was
that
passed.
there was some-
Anyhow, let them produce a record, whether that, you never ask for a record, the document. It's only on 24/2/2024, first time you wrote a letter.
The rule 15 days mandate.
Whatever, you file your affidavits within 3 weeks.
I bring last minute fix of the date because it's also affecting my
It
role.
will be after 3 weeks of fix a date. Yes,
17th July.
communicate.
Item number 3.
Number 3, man. In the instruction today, may I say, keep it to Monday, so that I can furnish the instruction, because today they are giving me the instruction.
status of representation. What is that? What is the status of representation? That is,
They wanted the lease to be renewed or to be extended for a further period. Just give me instructions, what has happened?
Yes. But that is because the wrong department, they have included.
Some government advocate submits that he is expected to receive the instruction from the responsible officer, from the department concerned in course of this day, and prayed for the accommodation stop. This is the matter on Tuesday.
Well, item number 4.
This one form of clear was. On Wednesday, 53. This is the authority constructed a toll gate for which the villagers are facing inconvenience to access their lands where 800 acres of land are there.
These toll gates are fixed at the NH highway, National Highway. Where is the difficulty? Aren't they?
There was a road. Can you have a glance to?
There was a road, on the road they have fixed the toll gate.
Yes, ma'am. So that is not the problem.
Then,
We have no grievance regarding construction of toll gate, ma'am.
then,
Can you kindly have a glance to Annex 6? I have annexed the map.
yes.
Kindly have a glance to plot number 290. And thereafter a black mark is there opposite. And this was the road. and this road crossed the NH and came to opposite side. By virtue of that toll gate, they have closed that road so that the people could not access their cultivable lands. So our grievance
This
is that
can't be. This is what you have to take. If you can't prevent the access, and then they become.
National Highway.
Have you issued a notice upon them?
No, first time,
Yes, issue notice.
first time.
National Highway. But returnable after 3 weeks.
Opposite part number 1, you are appearing.
Yes.
Waves notice, extra copy. Yes. 3 also you are appearing. 3, 4, 3, 4, 3, 4, 6 you are appearing.
yes,
Say 1, 3, 4, 6. Others represents within 3 days.
Item number 5.
For example.
Matter where the petitioner has submitted is deed pursuant to the Khordha district matter. That one disqualified in technical bid, one bidder, my lord, who approached this honorable court, behest of one association, and there is a stay order passed by the kindly see page 30. That page 30 annexure 3, Jagadamba Polymer Pricing Limited, disqualified in the technical bid. I am concerned with the Khordha district matter. Disqualified. Then he approached this honorable court in 1758. That's your lordship kindly say that read petition I have annexed that page 40, one association, North Odisha Chamber of Commerce and Industry, and 41, petition number 2, Jagadamba Polymers Private Limited. My lord, in which district he got the tender that he has supplied. Where he has not got the tender, he has approached this honorable court and getting an interim order. In this case, my lord, he used it because he is disqualified. He has suppression of facts, and I have intervened in that matter. And
Go get the interim order vacated.
my lord, that's now this is assignment just time before your lordship. My lord, because I have filed this writ application because my lord, kindly see my lord that I have filed intervention and he has filed objection, but there is no order passed in the intervention.
So what? So you have a remedy. You have a remedy, madam. If there is already, sir, if there is already an interim order operating against them, can another bench say that no, you proceed, which is contrary to this? So
This is not applicable to this case.
show us that this order is restricted to what and why it is not applicable.
That's
Show us.
my
show
lord,
us.
you see, my lord, the prayer made in the writ application. That is
That was quoted there.
my lord, that is in MSME policy decision. This is the tender. The petitioner number 2.
We are concerned with the interim order which says that the state is restrained from proceeding with calling for a bid as per Annexure 5. Are you claiming any right in terms of Annexure 5?
My lord, so time is MSME. I am also MSME.
True.
That's why my lord.
Now,
this is the blank-
no tender bid would be called. That is the restrained order.
That is regarding the violation of procurement policy. Here is a tender. There is no violation of procurement
I
policy.
do not know if it impinges upon them and if they are bound by the interim order.
I will tag with this case.
Sorry, this can't be done in this way.
My lord, because
We
kindly
are
see,
we are going to dismiss your writ petitions. You are really trying to jump the forum. You trying to invite the court to take a contrary decision. This can't be. No. Judicial discipline has to be maintained.
the tender matter for the strongest possible reason and for the shortest
Sir,
possible
whatever
period.
rightly, there is, madam, kindly consider, you know the law. Rightly, wrongly, an order of injunction is passed by the court.
My lord, that's right.
That is a coordinate bench. Can another coordinate bench pass an order which would nullify that particular order?
No, my lord, I am
When
saying-
you have not asked,
I am saying your lordship may tag this matter to see that whether
why should we?
my lord,
Why every time? This is a innovative device,
your
madam.
lordship assignment.
No, sir. This is a innovative device to have these matters. This matter pertains to which roster?
Your Lord.
Yes. So it will take its own course.
That's why I'm saying, my Lord.
And for this writ petition, it cannot be.
See page 81. Why my intervention?
Your intervention application has been allowed or rejected.
That's why my prayer.
Allowed or rejected.
But there's no order passed.
No order passed.
Page 81.
So mention your intervention application to be listed.
That's before I am lordship because
For that writ petition is filed.
the lordships are sent.
To achieve something indirectly which you cannot achieve directly.
My Lord, my prayer before your lordship
Sorry,
is that
we can't.
it is your lordship.
I am not groomed. I am not groomed in this way. I have a strong reservation, madam. No, these are the devices to get something.
Objection to intervention, my Lord.
Let them do it, madam. That matter will be decided when the matter is listed. You have already approached the court who passed the interim order. Intervention application or addition of party application is already there with you. So
Like they have filed objection and no, my intervention is not.
whatever the court has to consider whether you are a necessary party or a proper party in the perspective of the cause of action. The court will decide.
That's why
Then you can't.
No,
This is writ petition to get that matter listed.
It is for your lordship because from we have invested so much in that tender process. Somebody who has participated and declared disqualified.
Matter out of which this application arises was never before this. So similar matter. Yes, mentioned. I just indicated.
Madam, why there is a, I do not know, this is a procedure which is adopted here, that while filing the petition, you'll have to give a declaration that there is no other writ petition pending. And now you say that there is already a writ petition pending.
Based on my no other
Yes.
intention pending.
But now it
It
is not said.
You are an applicant in another writ petition where you wanted to be added as a party.
That has not been allowed.
So that
My Lord.
whatever you knew there is another proceedings which really impact your right, but then you have applied for your addition. Will you not say? This is a very, very casual declaration.
Madam, another thing is you are saying
That's
say not allowed. It is not allowed.
Right.
Madam, be careful. You have filed intervention application. There is no order passed therein what you have submitted. Now you are saying not allowed. Is it disposed of? Dismissed that IA?
They have time granted to file objection. He has filed objection. They
Is
have
it-
to no order passed.
So is it dismissed or is it rejected? Your claim has not been rejected. So how can you say that? Not allowed.
I am saying that it's not making a decision, not deciding that matter, hampering
Will
me.
you not disclose in your, if there is a format and there is a requirement of this court on a procedural aspect? How can you give a wrong information?
That I have understood.
It's not a, madam,
I'm saying
I have been taking a very strong reservations with this regard there, and I have been imposing a cost on the advocate
but in the prayer,
for this kind of the things. I am bound by my own judgment, madam. Unless you show us that I am wrong, I will not.
see my prayer, page 7.
Suppression, conscious wrong informations. No, I will not permit.
Page 7. Kindly see, in my prayer, I have categorically stated this. That WPC 175 page of 2000.
Will that close our eyes to this declaration that the matter out of which this writ petition arises was never before this honorable court.
But this
And particularly when you have enclosed the entire writ petition of that writ
in the
petition,
present form is not.
copy of that writ petition in this writ
But in
petition.
present form, it is never before. That is the
Madam, can you do that?
typical thing. My lord.
Copy of writ petition you will enclose here as a annexer.
My apology to this unconditional, because I have stated everything. I have not suppressed anything that I have intervened. They have filed objection. There are 50 state opposite parties. That's why they are not able to file the counter. And the matter is adjourned to a long date, my lord. That's the point, my lord. It's a long date. It's a commercial matter. I have deposited a good amount, and that has been for the stay order.
No,
They are not filing
No,
counter.
madam, the
That's
conduct,
what my lord-
the conduct and the manner in which it is moved by your client. No, sorry, we can't. Maybe, we can't.
I have stated
We
everything.
can't.
I have not suppressed anything.
No, whatever.
Only the declaration, my lord, says in computer copy and paste. That's why, my lord. That
Why are you not? When you are putting your signature at the bottom of the writ petition, don't you owe any responsibility that what statement has been made or prepared?
This one, that's right.
No.
Your lordship may punish me
No.
if doing anything, but my
Cost
cost, my lord. Yes, I
Yes.
will pay. Because of
And
it, I will remember in future. I will never.
6 digits. Never less than that.
But I for
6 digits.
let it be 4.
No, 6 digits.
Remember it in future that I will check up that. But because in prayer I have made it. Yeah, but my unconditional apology, my lord.
That matter, the interim order is operating,
Yes, my lord.
That is operating.
and you can't call a bid.
And moreover, my lord,
And this interim
The
order is
other
in respect of this bid. The interim order is in respect of this bid.
Yes, my lord.
yes, ma'am.
So,
And moreover, my lord, the other writ petition has been filed by North Odisha Chamber of Commerce and Industry. They are also not party to the present writ petitions.
But second writ petitioner. The second petitioner, my lord, that is the suppression I am saying in that writ petition. The second petitioner,
madam, if there are 2 writ petitioners, they jointly filed a writ, and you are agreed by an order which is passed in that writ. Will you not implead both the writ petitioners as a party respondent in a subsequent writ petition?
petitioner, not tender. He has never challenged the tender.
Sir,
That's the
Madam, will you not, if there are 2 petitioners in the writ petition, how can you choose to implead only one petitioner and omit the another petitioner? He is a beneficiary of the order. If he is also, what are you talking?
because he has participated. He has filed this case.
Probably my learning of law was very absolutely wrong. Sir, madam, kindly visualize when a petition, single petition is jointly filed by more than one persons, and an interim order is passed in that proceeding, then it is in favor of all the petitioners who have jointly filed. When you wanted to challenge, then will you not implead all the petitioners as a party? Can you choose only one of them as a party as you think he is the only person? Suppose if this order is interfered with, this gentleman may come and say that I was not heard because I also secured the order that was passed. Is it not a gravest of injustice one can perceive?
He has participated in the tender.
So I am not concerned with this. When 2 gentlemen have already filed, suppose your clients, 2 brothers, they filed, one may be affected, and then another proceeding is filed against the one brother, and then it will bind the other brother as well. Then how can it be?
My prayer is, my lord, that let this.
Sorry, we can't.
That I will implead him as a party. My lord, petition number 1, because he is
Whatever you pass, because I am, you know me.
My lord, implementation of policy decision, that is nothing to do with the tender.
Nothing. Procedurally, everything. Dismissal. There is already a restraint.
Your lordship may permit me to withdraw to file a better application. That's what my lord. I will withdraw. I will withdraw to file a better application.
File, ma'am.
My lord, I will file.
Convince my brother, I am not convinced.
No, your lordship, my lord, my unconditional apology for that. But because of this situation, my lord, is suppressing everything.
I have never
prayer
come across,
itself is
with all humility in my command, I never come across these kind of a petition. In my career over there, in my career over here. No,
Your
peculiar
prayer-
does not mean that you will dispense and bypass everything.
Not applicable.
Your prayer is misconceived, as if we will sit over an interim order passed by another division bench.
No,
Coordinate
I
bench.
am not saying that.
No, madam.
I am not saying to vacate.
No.
I am saying.
Let us read for all the members of the bar to understand. You say that you do not want to vacate, where the interim order is not to call for any bid and not to proceed. Your prayer is direct and order the opposite party number 2 to finalize the tender. If there is already a restraint order, by this we have to finalize the tender dated such and such under annexure 2, and further please to declare and hold that the order dated such and such, which is an interim order passed in WP number such and such, has no application in the present case at the behest of the opposite party number 4. I have not my incompetence and sorry, I can't understand that you do not want the vacation of the order, but this prayer has a larger impact in nullifying that order.
So that may be.
I do not think so.
But that may be tagged up to first decision.
It's a bad case to start the day with.
Withdrawing. I am withdrawing. I will file a better.
It's a bad case to start a day
No
with.
better application. Withdraw.
Because that matter.
File memo to withdraw. That's all.
The opposite.
No liberty.
That cannot be.
No liberty, madam.
Listed, my lord, in near future.
Madam, no liberty. Only unconditionally you withdraw.
Listed in near future.
If you want to withdraw, you withdraw. Otherwise, we will pass orders.
And there are 50 opposite parties like the government. All DSW of the district has been made parties, and all the tender process in Anganwadi has been stopped by using that order. And he participated also in the tender, and he has declared disqualified. Thereafter, he used this order. And this association has come espousing the cause of the.
Let us pass the order. Let us pass.
And I will withdraw that order. Otherwise, my intervention application will.
I do not know.
Influenced by that order.
My brother has already indicated. I have not said anything. I will simply dictate the order. If you say, I will dictate. It is up to you. Convince my brother. Hey, what do you?
Well, I will withdraw the application.
Tell my brother, convince him.
Liberty.
No liberty.
I'm simply withdrawing.
Convince him.
I know, my lord, that whatever lordship is saying that because of a peculiar situation, whether my lord, my only prayer is.
Madam, either of the two.
Commercial matters.
Don't waste time. Either of the two.
My lord, I'm saying I will withdraw.
Withdraw. No liberty. File memo.
Well, I'm fine.
Yes. Kabasdi.
But that is.
That other matter which I'm agreed of that is the lordship.
Yes.
Next. Item number 6.
This that matter which she was mentioning. Other matter. The other matter. It is adjourned to 16, so list it on 16.
Specific date is there.
Yes.
Item number 6, sir.
That is not. Plus, my reference in this public interest litigation is, plus the jail is being constructed on a gocher land loss.
What is constructed?
Jail loss.
Jail.
Jail.
Okay.
Plus, is being constructed on a land used for pasturage, gocher. And for that reason, we have written to the collector.
Yes,
It's for the first time to take instruction.
take instructions, come after 3 weeks. 3 weeks, let him come.
Yes.
Item 7.
Notice means
We have already issued a notice.
one private authority is there. Because who has been given the work by virtue of proof.
Notice of the private response. Is called the
Item 7.
So the status can be maintained because in the meantime they are
dangerous. I would be beseeching you to read the judgment of the Supreme Court in Kishore Khaitan's case, 2006.
Item 7.
Section of the petitioner is an NGO. They, the municipality, the Bhubaneswar municipality, they go for bids, inviting tenders for the job of door-to-door collection of segregated municipal solid waste. They go to each door, each house, collect the solid. For that, they put up a bid.
What to collect the
Waste materials from each house. From door to door they go, and that job is put to auction, bid, and successful bidder comes and does it. It is generally given to NGOs, like the petitioner. Petitioner also is. Lord, in 1921, I got the test.
1921?
Sorry, 2020. I'm sorry,
It's 2021.
2020.
You got the
For 3 years.
the order,
Yes.
work order.
Thereafter, it was extended from time to time. And the last extension is till 30th of June, this 25.
Right.
So,
So that has expired.
it will expire within a day or two.
Yes, June. Yes.
Yes. Now, in the meantime, they reverted back to bidding process.
Correct.
At page 93, kindly see, Lords. Page 93, they invited notice inviting tender there.
Correct.
Now, they have given the dates. There is one pre-bidding meeting.
Yes.
Pre-bidding meeting I attended.
Yes.
There were certain discussions, parlance, and certain defects were pointed out. They issued corrigendum on that basis, and I applied these applications were made. And thereafter, they wanted a clarification. Now that is at page, let me say that. 254. They wanted a clarification at the page 254, page annexure 12, that therefore you are requested to provide your clarification, not later than so and so, telling which it shall be presumed that your net worth is 50 lakhs during the financial year. Clarification was sought.
Yes.
And we clarified that.
Yes.
We clarified that as page 256. We gave the required information, documents, everything. But thereafter, the matter remained dormant. They did not proceed any further. But my apprehension at present, my tenure is going to expire 2-3 days after. But in page 93, for it to go back again, Lord, that they have in item number 5, date and timing of opening of proposal.
Yes.
That is 5/11/24.
Mhm.
After that, they have not called. And it is my apprehension that they have not called us not given us any letter, not informed us anything, but proceeded to consider the private opposite parties before the motion, which have made them parties.
No, he must have participated in that.
Pre-meeting meeting.
No. This is what they wanted both the general and technical bid
Yes.
as well as the financial bid.
Yes.
And they invited the bid documents from all the intending participants. So the intending tenderers,
Yes.
they participated. Now they have to finalize the tender.
Yes.
Finalize the tender process. Then if they found that the private respondent is the lowest L1.
They will give it. My apprehension is that without informing anything,
Why?
I should get a result that your bid is rejected.
Why? Your bid is rejected means
Someone is selected.
if they declare, they have to declare it.
Yes.
They will intimate.
That is what they have got.
So they will declare. Why they are sitting tight over the matter?
Yes.
Who is for the? Why you are sitting tight over the matter?
I filed the cabinet and he has also solved the copy of the petition report. And I have also prepared the instruction. Practically, the cut-off date was 5/11/24.
True.
When the amount that the net worth certificate should be of 31st March 24 up to 50 lakhs. But he submitted more than 54 lakhs up to 30th October. So that is why the clarification was sought for. And it was also, as pointed out to his page 224, it was pointed out, may place it also. In inviting reference to the subject cited above and upon evaluation of the application submitted in response to the
Mr. Panda.
RFP,
From where we get it?
From
where we get it? From which page are you reading?
Page 254. Annex 12. That you are placing. John Friend was placing.
Yes.
This is the clarification sought for on the ground that the requirement up to 31st March, not up to 31st June, 31st October. So, because your document.
So this clarification.
So that.
Sir, this clarification was sought by you.
Clarification of what I gave to submit.
By 7/3, and you have written a letter.
Mr. Panda, Mr. Panda. My lord desires to ask you a question. Please hear. Please hear and reply.
Ma'am.
By this letter of 3rd of March 2025, you have asked for a clarification from them to be submitted by 7/3/2025. Right? What clarification they submitted within that time? Show us.
50, page 250.
Instead of clarification, they tried to submit a new fresh document.
I do not know. Please show us.
That is a page 256.
250.
Because my lord will find at page 256. This document was inserted subsequently. The last date, the date is given below 6/3/25. That means it is a post-bid document, a fresh document together. That is why the tender committee rejected it.
Have you communicated that your bid is rejected on that particular technical ground in a technical bid stage? Did you communicate to them? I'm asking, did your authority communicated this to them that you are disqualified in the technical bid? No.
Yes, my lord. Those documents I am finding.
Mr. Manoj Panda, you try to assimilate the question which we are posing to convey him so that he can reply. Right?
What your lordship is asking is at page 250. 250. The clarification by 7th March, they were there. I gave it on 6th March.
March 25.
Pardon?
6th March 25.
They wanted it by 7,
25.
3/22.
25.
Yes.
They wanted it by 7 March. I gave it on 6.
Yes.
My only apprehension is, sir,
Yes. What was the requirement?
By 31st March 2024.
Correct.
Network. So he
Yes, given. Yes, given.
Proceeding the
Content is given.
October, till October.
No.
the final notice
Look
for
at
closure of
260.
Now,
closure annexure 9. Page 53 of my paper.
this is what we say, that it is post report.
It is a.
But they have to ask for clarification.
Clarification. Network is up to such and such. He is, or his network is still up to God. The contract says no, it is a. Yes.
Not as he might come first and never glance please.
But within your extended period, he has clarified that by March
He has not
2020,
clarified. He
this is
he
clarified.
has introduced one more document.
No,
Post report.
no, sir. If you come to page, tell him to come to page 260.
My lord. Yes, my lord.
You are stuck up with the date at the bottom. Please read the content. Read the content. We hereby certify.
My lord, we hereby certify that the position of assets and liabilities net worth of Messrs.
Such and such
Jubra, Malisai, Square, Kotak,
as on.
PAN number so as on 31st March.
That is what is the last cutoff date.
My lord.
And then it may be signed subsequently by him on 6/3 because you sought for a clarification. So this is what a clarification which is given.
The original document he has not produced. The original document I have given in the counter, that is at page. The original, that is the whole dispute. Because the post bid document cannot be accepted, that is the problem. In the original.
Why you ask for a clarification then? You could have rejected it. No clarification is required.
It was clarified. There might be some clerical error, arithmetical error, something, some writing, but those documents had it been tallied. My lord, kindly permit then at page 22, my lord, kindly have a glance. That is the original document is submitted on 1/11/24. At page 22 of my counter name.
It was as on 31st
This was
of
the original
October.
document he
It was
produced.
as on 31st of October.
In that document,
That is why they have asked for,
Ask for a clarification.
whether by March they had more than 50. That is the clarification he has given, that though the original certificate speaks about the net worth up to 31st October is shown to have been 54 lakhs and odd, but by 31st March 2024, it was 51, which is more than 50 lakhs.
Sir,
So
please,
they have certified it as a clarification.
please consider the case in a more pragmatic manner. You have floated a tender inviting those applications. One of the conditions which you have enshrined is that the participants or the intending bidder must have the solvency, that is a 50 lakhs at least the worth they must have. As on 31st March 2025. No difficulty. They filed their bid document within that particular last date of the tender, filing of the application. They filed it on 1st of November it was on 11th November, it has to be filed.
5/11 was the last.
Correct. So they filed it on 1st of November within the time.
Within the time.
But in the net worth certificate, they have said that their worth means the solvency till 31st October 2024 is 54 lakhs and odd. Correct. Now the confusion arose in your mind that if 54 lakhs is their worth, it might be that if it is taken up to the month of March, then it may be less than 50 lakhs. Because from March to October, their net worth must have increased.
It's not that much.
More. So if it is taken as a base period, 31st March, it might be that it is less than 50. You issued a clarificatory note or a letter that what you have said, please clarify your position. And you extended the time till 7th of March 2025.
Yes.
They, prior to 7th of March 2025, issued that no, actually up to 31st March 2024, their worth is 51 lakhs and odd, which is more than 50 lakhs. And in between interregnum period, it may be more than 3 lakhs has been added to it. So similarly, once you ask, first thing is you were not under the obligation to ask for any clarification. If the document is not in conformity with the terms and conditions of the bid document tender, you could have rejected that this is not in conformity with this. Where was the occasion to ask for clarification? The document is not in conformity. That's all. You could have rejected it. You gave them a last gasping resort. Rather, give them some kind of a more oxygen to them and then ask for a clarification.
May I be excused?
Clarification of what? Clarification of that explain and clarify about this network. They have explained.
One kindly case. Because it was up to October, the committee thought it might be a typological mistake. Instead of March, it has come up as a date to October. So that assuming had given the same document, giving up to 31st March instead of October, had it been written March. So this confusion might be
where is reflection? Where is the reflection in your letter that it is only clarified?
The committee has taken note of this at
Page
34. The tender committee decision
of
counter page 34. Counter page 34. That is the proceeding of the tender committee. It starts from page 30. And at particular page at 34.
Yes.
With regard to the petitioner.
Yes.
Serial number 7. The rejection ground and Messrs. The Sanskar. The applicant has submitted its work experience under IEC and support for door-to-door.
This is after receipt of this clarification.
Yes, madam. And finally,
Mr. Panda, while issuing that,
let me place it. If my permit me, I can place it.
Prior to issuance of that clarification, seeking for clarification, have you given this reason?
Madam, the applicant has submitted its work experience under IEC and support for door-to-door collection of municipal solid waste in top 35 ranked city under survey count 3. Rank 34.
This clarifies what is rest of it. Have you read this resolution you are reading? Have you seen the tenet? What was really passing through the minds of the authorities? Please read the first paragraph. You have not said that it is a ministerial or I would say clerical error.
No, this is the reasoning that has been given by the.
Please, the reasoning is what you are saying is just contrary to the reasoning which the authority has given. Read the first
I
paragraph.
support the reasoning.
Please read, sir. What you are saying is reflected. Please read. The page 34, first paragraph under his name. Please read. That's my request to you. Please read.
Yes, yes, sir. First line I read, second line from start from second line. 35 rank city under Swachh Sarvekshana 23, Bhubaneswar Municipal Corporation rank 34, which is authentic and has also submitted the certificate from chartered accountant with valid routine number stating annual average turnover 5.84 crores in the last 3 financial years, that is 21, 22, 22, 23, 23, 24. However, the committee noted that
read very carefully this sentence.
Noted that the applicant has submitted 0.54 crores, that means 54 lakhs, as on 31/10/24, whereas the stipulation required the net worth figures as on 31/3/24. BMC by letter number this 6/3/25 sought for clarification
in this regard.
And
in this regard, that means
yes,
he wanted the authority was that when the requirement is that you should show your net worth as on 31st March, while you have shown your net worth as on 31st October, so the clarification is sought for. He then says that up to 31st of March, my net worth is 51 lakhs, which is more than 50.
Mirror. One more.
It's not a clerical or ministerial error you are asked for.
What clerical, my language, but virtually, I must.
And 6.3 letter. And 6.3 letter does not really talks about anything like this.
Let me plus two more.
Please.
So next paragraph.
Yes. Not next paragraph. Continue.
My lord. Sought for clarification in this regard, and in response, the applicant submitted a fresh certificate issued on letter 6/3/25, certifying net worth figure of 0.52 crores as on 31/3/24.
Correct.
The committee then referred the audited statement submitted by the applicant, but not able to tally the above said figures submitted in the CA certificate. Further, the committee also referred the provisions laid down in the procurement guidelines issued by the state and central government. The committee then referred the provisions laid down at serial number section 545 of the manual for procurement of works 2022 issued by the Department of Expenditure, Government of India, that states during evaluation and comparison of bids, the procuring entity may, at its discretion, ask the bidder for clarification on the bid. The request for clarification shall be given in writing by registered public speed post, asking the tenderer to respond by a specified date, and also mentioning therein that if the tenderer does not comply or respond by the date, his tender will be liable to be rejected. Depending on the outcome, such tenders are to be ignored or considered further. No change in price or substance of the bid, including
specification
annexure
shall be
30.
sought, offered, or permitted. No post-bid clarification
Where
as the
letter asks-
initiative of the bidder shall be entertained. The shortfall information document should be sought only in case of a historical document which pre-existed at the time of the tender opening and which have not undergone change since then. As per the above provisions, the committee resolved that the claim made by the applicant for meeting the eligibility criteria with regard to the net worth cannot be accepted. Hence, the applicant is found non-responsive for next stage
Right.
of bidding,
I have read.
that is evaluation of
Nothing
the
has been-
technical proposal. So now, the post-bid document submitted, had it been as it is sent, but only October instead of October, had it been only March, it is to be treated as a historical document. Now a completely new document obtained as a post-bid document, so that to patch up the lacuna. That cannot be entertained. That is the whole.
That is not,
decision taken by the-
that is not a lacuna, sir. That is not a lacuna. You have your authority quoted a particular provisions, that's the policy. That provision also does not talk about it. Even your letter dated 3/3/2025 does not really impinge upon the same.
The spirit of the letter is this.
That is what you have. You can't make out your own case. If the authority has not indicated anything, can you make out and improve your case? You are trying to just make out a case like this. Please come to the letter dated 3rd March 2025, where you extended the time and sought for clarification. I again said that if it is not in conformity with the requirements of the conditions, you could have rejected. Why clarification?
What I get to submit.
Look at it.
Clarification and submission of a fresh document.
Please, that is what is the mind, I would say, that the authorities are stuck up with. Please look at your letter dated 3/3/2025.
Minor.
You say that inviting reference to the subject cited above and upon evaluation of your application submitted in response to such and such with amendments under the pre-bid clarification, both under reference, it is observed that for demonstration of a minimum eligibility criteria prescribed at clause 5.3.2, which states that the agency must have a net worth of INR 50 lakhs during the financial year ending 31st of March 2024. Your agency has submitted certificate from a chartered accountant certifying the net worth as on 31st of October 2024 as against the stipulation made for the net worth as on 31st of March 2024. Therefore, you are requested to provide your clarification not later than 5 p.m. on 7/3, failing which it will be presumed that you have no justification to offer and suitable decision will be taken in the BMC as deemed proper. It is also made clear that mere submission of reply will not be presumed as your eligibility under the tender for the subject work. So this is what you really say, is that why you have given up to 31st of October when our requirement is 31st of March. So you sought for a clarification. She says that whatever the chartered accountant as on that day he has submitted, I am clarifying that as on 31st of March also my net worth was more than 50 lakhs. So a chartered accountant, when he has done the audit and then he arrived at its decision that what would be the net worth, how can you predate the same? How can you predate the same? Let us example, you say there's only the alteration of the date. Suppose if there is an alteration of the figure as well. Can he not do it? It is a typographical error. Instead of 4, it should be 1. Can he not? What you will do in this situation, it will not arise in this case. Hypothetically, suppose, forget about 31st of October. A clarification is required. And he says that a 54 lakhs, the figure 4 is erroneous, numerical. It is 51. What will happen? is a numerical, clerical mistake. That was not intended. You say you show your net worth as on 31st of March. Because the authorities have an impression in their mind that if 31st March is the base period or a last period, the 54 lakhs is a very marginal one. So their net worth may fall or come below 50 lakhs. So that's why the clarification was sought.
One more thing.
And if they are showed, no, it is still. What is the difficult? After all, it's a competition, sir.
Added to it, page 28. I never classed it. Yes, 28 is the comfort.
Yes.
What led the committee to come to this conclusion? My lord will find it.
Yes.
In both the documents, my lord will find.
This was a balance sheet.
345.
This is a balance sheet, sir.
Yes, my lord. My lord, left hand column, my lord will find.
Yes.
Unsecured loan is 21 lakh.
What?
63,000.
No, unsecured loan.
That one column, 1, 2, 3, fourth column. Liability side.
Yes.
Liability side, my lord will find the unsecured loan. There is a figure of 21 somewhat. But my lord will find the either of the document. In the subsequent document also the page 27, my lord can have a glance.
Yes.
Page 27, my lord can have a glance.
Yes.
Bank loan, unsecured loan. At page 27, my lord get. Column
Yes.
number B, liabilities.
Yes.
Bank loan, unsecured loan, nil. So, both the documents he filed. Both the documents he filed. So, when the committee compared it and virtually went through, but he suppressed the many things that he has not given a correct statement as is required on the law and as is required in the NIT. If he has a loan of 21 somehow, why he has suppressed that in the net worth certificate mirror? Thereafter, the next page is also there. At page 29. And if that liability side is gone, then definitely there cannot be more than 50 lakhs. He has suppressed that.
Are you a commerce? Have you any commerce background? You have any experience?
But I just bring to kind notice of my lord that this is the tender committee. Tender committee has noticed it and has gone through it, and thereafter has taken a decision on it.
Have you ever seen your ITR prepared by the chartered accountant? Have you ever seen?
That also
When he also prepares a balance sheet,
that is
your total income which you have personally. Have you seen that?
I have not seen, but one chartered accountant has prepared this two.
You will also have an unsecured loan in your balance sheet, which you do not know. What is that? You should know that. Why? What is meant by the unsecured loan?
And chartered accountant in all the cases is one.
True, because he knows the accounting. He knows the accounting methods.
So
These are
liability.
These are the accounting methods.
Madam, deducting liability net worth does not count.
Kindly visualize when he gives an audit report, he owes a greater responsibility. You do not know. If something comes, then in the chartered accountants, the association, Institute of Chartered Accountants, his license is liable to be cancelled. There are multiple things which can be said to be an unsecured loan. It is not a simple loan in a civil matter that somebody has lent me and money I am required to give them, so it becomes a loan. No, there are many facets of loan. Even a recognition of my liability to pay in future. That's why in an expenditure column, he has said that how much expenditures one has to. Yes.
I will permit it to add also. It page 28 that I show my law. The right hand side top column.
Sir, I am also not very good accountant. I'm not a student of commerce. I am not a student of commerce, to be very frank.
But my
brother maybe.
My knowledge, you are is a master of it.
I forgot it. What I
With regard to
learned in college.
so that cannot be net worth of more than 50 lakhs because it might not be the right column.
Sir, I am asking you, are you an expert accountant? I mean, you means your authority, that the tender committee. Are they an expert accountant?
Yes, Mr. Tender committee, there are 7-9 members.
Correct. Is anybody a chartered accountant?
No,
Is an expert in the field.
And they have not, Mr. Panda, Mr. Panda,
Chief Finance Officer.
Mr.
I'm
Panda,
asking, I'm again, have they raised a finger that this audit report is wrong? If they raise a finger, I will also refer the matter to a chartered accountant institute. Both the finance officer and the chartered accountant who submitted, they should be dealt with. And if anybody is found to have committed any misdeed, then the institute will take action against it. Even your finance officer or a chartered accountant. We will refer.
If minority permit, I can also call my finance officer so that to explain with this regard.
Why, sir?
Because I am not that conversant with regard to the accounting.
Have you seen that? Have you remember the observation of Justice I think Krishna here? The judge is not an expert of the experts.
Yes.
We don't have the expertise. Why we rely on those experts? Experts' opinions are also admissible in in the court's proceeding. Why the court relies?
But that is not
Because they are the experts.
Minority is expert of experts.
No. Nobody can claim that I'm an expert of an expert. Nobody. Even the judges are not infallible. They can also commit wrong. No difficult.
we cannot travel beyond this page 34.
As the Lordship rightly pointed out, that has this been the consideration there?
Absolutely. They could have reflected it that please clarify whether the date which you have given, there is any typographical error or with your clarification. They would have said, no, it's not a typographical, we have given. Then you take a decision, no difficulty. Your clarification was sought as if what was your net worth at on 31st of March.
My lord, it
was not required, I tell you very frankly.
I humbly beg to submit, my lord.
It was not required by an authority,
Yes.
sir.
Yes,
It could have rejected the
it was actually not required.
technical
But I may,
stage.
one more thing I may say, because he was awarded the work 651 and he has been working, which will close up to 30th June, this 30th June. So he has some experience in the office. And that is the reason that if anything,
yes, proceed.
if
I anticipate where you are heading.
might have committed in submitting a document, nor that is expected of bringing a new and fresh post-made document. It was never told. He was never told to bring a post-made document to patch up the lacuna. You may clarify what is what.
What clarification?
Yes.
What clarification? Sir,
seeking for.
Sir, suppose if it is coming before me, a document, without saying that what clarification. I have received his document clarifying. What does it mean? What he will clarify? When you indicated that you are supposed to give a certificate as on 31st of March, please clarify your position because you have given a certificate up to 31st of October. What it conveys? That they have to say yes, up to 31st of March, this is what I have to.
For a moment, if I may, I may suppose in a given case, he would have submitted the same document, only correcting October in place of October,
You could have-
correcting
you could have-
March, correcting March.
I accept.
Then it is a historical document. It exists.
Historical means what? What is the char of a historical document? I do not know. I am also not an historian as well. What is meant by historical document?
That means previous document.
No,
That means
it's not a historical. Not a historical document.
I mean to say.
So in that
to explain to that.
event, sir, whenever the authority is found, they could clarify in the language that this is what we found. Is there any typographical or clerical ministerial error in your audit's report? Clarify.
Those
They
marks are not there.
they have to then say, yes, there is no clerical or arithmetical error or ministerial error. This, now we are submitting the document. What you say is correct, but you did not spell out that. Nor your resolution talks about this. It is not the constitution.
Something in my language, but the language that has been used by the committee, that is placed before mine.
But language does not suggest what you are saying.
It's not my, I may be fault at my language, but
No.
it is
Sir,
observation. I placed it before mine.
What the authority is saying, you are arguing on the basis of the affidavit given by your client. But from the language, we do not find in that it really conveys that message. If it does not convey that message, then where is the difference?
At the cost of repetition, only
In your affidavit, you tried to cover up that, which is not there in the record, that is page 34 in particular.
maybe something.
That was not your
my
decision.
language- I
You have
tried-
traveled beyond the decision.
But my lord may ignore my language, but my lord may
No,
adopt
sir.
the language that is being used by
Stated that in
I
your,
am not talking about your language.
No.
Your language is a reflection of your authority's language. You can't go beyond the pleading. You are talking within the pleading, which your authority have affirmed. But I find that this message which your authority is sought to convey through you is not is in consonance with what they wanted at the initial stage. So disparity is evident. What to do?
One more thing. Yes, my lord. I got that point. This next, my lord, I wanted to.
Yes, then there is
I have already submitted before my lord that the document he submitted post-with document pursuant to seeking clarification, that does not also tally with the document that I have shown my lord, because the at page 28 and 59. 28 speaks as per schedule 1. Annex 7 to page 28 of my counter mirror. The right hand column, my lord will find. Tick that, sir.
What?
My lord will find as per schedule 1. The schedule 1 is next page. The figure is there, 25 lakh 26,992.
Yes.
Now that is
That is
The next page is the annexure one, the schedule one. Written about in the third column, schedule one. With the schedule one, column number 3 includes furniture and fixture.
Yes,
Matter.
yes.
That is nowhere reflected in any of the document. So all the mathematics totally go.
This is what.
So that is the committee has taken care of the documents that is submitted pre-week and document is submitted post-week. The post-week document even if taken and if liability is taken out, then bank loan is not shown. This type not only suppression of act, but if that is also deducted, then does not come up to the PASNA. So that is the reason that the committee has given its reason, given its decision. Not to mind, and in the meantime, it is a sanitation problem. And it will end on the 30th of June, this month, 2 days after. And in the meantime, agreement has been executed. The successful bidders, there are 4 bidders came up, 1 bidder left. So now there are 3 bidders. They are also made parties. They have also made the agreement. And it is a sanitation, door-to-door collection garages. If that will not be worked out, virtually serious chaotic situation will be there in the township. Those things are also.
So that is not stopping anything. If 1 year back,
and that is why he has also been given notice that you stop it by 30th June. That document that document is there at page.
I have given.
That document below I have given at page.
Next to 14, I have given. Page 263.
That is page 53 below. Can have a glance to my counter. At page 53.
Same as I
The
understood.
closure notice that has been given on the annexures 9. Not only that, he has also made an argument that throughout his career he has not been blamed. But to answer to that, we have also given Annexer 8 series, where he has been penalized, he has been asked for show cause, and he has been imposed penalty for number of times because of his laxity of works, all the fees.
Again, not
So now his continuance is not also fair with regard to the past experience that we have already
that is not the
seen.
consideration there.
And
Developed.
had he passed in this test, then the thing is different. But if you once he introduces a press document, post-bid document, then others may also do that, because there were 9 bidders. 5 bidders were technically not found suitable. So the financial bid opened in respect of 4 persons. 1 person left, 3 persons were selected. Now there are also opposite parties made in this requisition. When agreement has been made, everything has been done. Only they will start work from 1st July. And his last date of work is 30th June. And he has come at the end when only 2 days is left.
That letter was given only.
Only 2 days is left. So the ultimate consequences would be that the city will remain in the garage. No. That will, because it is a duty for door-to-door collection. Who will collect me? That is the whole problem will also. The otherwise it may kindly be kept in list. That's all.
Many cases are 4, 5, 6, 7.
Only 3 has been awarded. Why you have made so many private parties here? Only 3 is required because they have.
Now he says, just now he says, because I was, because I had made all the participants, the parties. So now he says only 3, because this he is just giving now. And I'm not, I bow down before your lordship, not one thing your lordship put it to, that you are giving all considerations which are beyond that phase factor. Had those been the considerations there, yes, your lordship would have. But you are now making out a new case here. That's I have made them parties for that reason. Your lordship has strike out those parties that because for abundant portion I had made all the work.
Who are the 3 parties in whose favor the contract is awarded?
No, 4, 5, and 7, because 4 were selected. 4, 5, 6, 7 opposite party to the writ petition. Now 6 has left. Only 4, 5, and 7. That is given at that 12 of my company.
You are the only person.
4, 5, 7.
4,
Who
5,
have
7.
been awarded. Who have been awarded the contract jointly.
Our contact is, I mean, online, I mean,
Jointly.
the work order has been issued. No, because there are 67 works and 6 packages.
Division on
Two
the basis
packages.
of certain wards. Only in respect of
Separate agreement.
separate wards.
Separate agreement for different works. There are total 67 works.
Just what you say.
May I just
At page 12 there.
The contract is awarded to him in respect of all the 67 wards or
67 works with 6 packages. 3 with the 3 opposite parties.
to him. Petitioner is awarded a contract for all the
Petitioner has not got. Okay. That is why I just
previously.
he was
all the 67 wards or wards.
given a contract in 21 that existed till 2 wards, not that
What are those
entire
few wards? What are those few wards?
that he can say and I can
that is
also,
at page 263.
What are the
1, 2, 6, 8, 14, 22, 23, 24, and 49.
That's the only.
No, those are three. At page 263.
And you applied for these wards only. Tender.
No, we had applied 67. Applied for 67.
All.
Again, my lord, I think what my learned friend is saying, counter he has given just now. He says that agreements have been executed, everything, but nothing is there. The letters, selecting them and closing my, those letters are added.
my affidavit page 12.
No, there is no document. I understand. There is no
Documents are
document.
with us.
What is this?
Page 12 million. Agent status. My counter.
Yes, page 12, your lordship says how this
work order has
where
been
agreements have been executed.
The work order has been issued to all the above 3 parties.
Yes.
The newly selected agencies shall take over the work with effect from 1/7/25. The petitioner's work under old agreement shall cease to exist with effect from 30th June 25.
Whereas they stated that agreements have been executed and
This is a formal thing that is automatically before taking of the work. After the execution of the agreement, the work order is issued.
Let us see. Yes.
Well, Payback lordship, that is since 11/10/2023 lordship. Letter of award has been issued in favor of me. Lordship, on the above the selection of the provided agents, I am lordship service provider agents. And lordship kindly come to the next page. I have agreement for 3 years, lordship, page 31. In 31/10/2023 lordship. And I am in operational lordship. And while this was the position, OP number 6 approved this honorable court. In writ petition number, lordship, I have quoted the entire writ application. And without making my party their lordship. And by interim order is taken on lordship by restoring his position in my contract. And now also consequently, Adexa 3 they have issued a turning page 36 lordship. I think the entire order lordship of the interim order. In writ petition number.
But that interim order is still operative.
Lordship, that is
So
it.
what can be done?
So lordship, what I pray lordship, let it be tagged on Monday with both the matters. So the lordship, I have filed that interim petition. They made an objection, lordship will file objection. In the meantime, they should decide.
No.
So both the case may be swapped lordship together so that it.
How can you seek a mandamus to cause that letter? That letter simply conveys the interim order passed by the court.
So lordship, I have filed petition there, lordship, for intervention and vacation of interim.
So whatever you go there and then pursue that remedy, but how the court can pass this order?
What I prayed to lordship.
Sorry.
Lordship, kindly see lordship.
No.
On page
You have
19.
seen the earlier matter.
Now page 19 lordship, kindly see.
Yes.
Page 19 lordship. 13/6/25 lordship.
Whatever the
I have,
reason,
lordship, during vacation, I have filed interim petition and
maybe
prayed for vacation of
pursue your
interim.
remedy there. Pursue your remedy there.
No, what I prayed to lordship.
No.
No, lordship, I have this.
We will go by the prayer which you have made in the instant writ petition.
My humble submission to lordship, this matter, despite judicial order, lordship, kindly see lordship. Lordship,
This can't be in a parallel proceedings. It can't be done.
seeking.
Sorry, is the parallel. What is the prayer which you have
Lordship,
made?
can come to page 20 lordship. Come to page
Yes, I am at page 20.
20. Page 20 lordship, leave this matter, that matter lordship.
I
Leave this
understand.
matter, we commence in 23rd June or
So
something.
whatever be, and my brother was a party to that
Yes, Lord.
order. So what more?
This
We
matter-
can't.
For the,
Despite this
we have
judicial order.
taken note of.
Note of.
We have taken note of. He appealed.
Lordship, I thought operation that was objection lordship, but despite they made a statement before this honorable court, I am in operation. And lordship, they issued
By
Annex
8, we
3.
have only extended.
No, simply.
They made a statement lordship, kindly see.
No,
Para
this
three.
can't be. This can't be. Same strict already. No. Same treatment. No.
No,
Here the only difference is there is no defect in certification.
Yeah, that's true.
The thing is,
only this attempt to lease that matter lordship, because the matter is not coming. That is all difficult with us lordship.
We are dictating this judgment and we can't hold. There is any case made out for that.
But lordship, that matter should be listed. That
That will be listed. That will be listed. You mentioned. We'll take.
sir, that will go either way. You are inviting trouble for your client. If you want, you
No,
proceed.
no lordship, I have now no hair lordship. No, they have
You have the remedy,
Since
sir.
we
You
have
could have
said-
mentioned the matter.
On that date, since you have said he is continuing, we have not passed any adverse order against you.
that and
That,
lordship, can
that
see Annex
is,
3.
that is the observation in that order.
Lordship, can see Annex 3 page 36. Despite the lordship's observation, they come up with this letter on
So,
26.
so there you have to raise the issue.
Yeah,
not-
I know that
not
lordship.
another
I am already there.
restriction, sir.
I am already there, lordship. I'm not saying that I am there, lordship. But only my humble submission, lordship.
That matter may be listed, at least restrict that.
You mentioned the matter, we'll take care of that, but this prayer cannot be allowed.
Then let's only say, Lordship, I have ordered this matter to pursue their Lordship, and I have.
That is up to you. That's your right is always there
So hold
to pursue that matter.
Matters have come, they are
No,
in the report.
no, that can't be. What cannot be achieved directly, we are sought to achieve indirectly. No.
That's it, then say I will order and I'll pursue that.
File this memo immediately.
That's it, I'm making statement.
Withdrawals. Immediately. Same order will be there. File your memo of withdrawals.
Lordship to pursue
Or-
that.
That is up to you.
But I think they can mention Lordship.
No, that's true. That is always, we never disallow any mentioning.
It is not coming, Lordship, that is.
So it will come, don't worry. Yes.
Item number 9.
What the challenge is to the variation in the financial capacity in the last tender, which is an extra 7 that I'm challenging. But before that, my lord, I'll just take the lordships to the earlier tender documents. If your lordships would come to Lord's page 39, that was the first tender in 2023, where I became successful and I am continuing. If your lordships would come to page 39 of the This is regarding manpower supply, Lords, for housekeeping and other maintenance works and security and everything. And the annual turnover is hardly around 1.5 to 2 crores is the variation every year, Lord, within that range.
Let them survey copy number 3. You are agreeing copy number 3. Manager. Instead of hotel manager, preparing the government of India.
Serve the copy, but
Serve the copy.
yes, my lord, my interim prayer is there. The reason, my lord, I'll just subject to your lordship's consent. I'll just place, my lord, 3 clauses. Your lordships may come to page
Serve the copy, come on 30th, we will consider it.
30th, my lord, it may
Monday.
retain its own position,
Yes.
subject to your lordship's.
Service 30th.
Yes, 30th is the last day of the contract,
Yes.
so.
Item 11. Item 11.
I'm appearing on behalf of this respondent on BC, my lord.
See, Lordship, Learned Senator. Council in Missile also permitted to allow.
What is the matter has been narrated by the Supreme Court.
Mine.
To rehear the matter, to rehear. When is the order of the appeal for? Lucky.
Actually.
So it is at the admission stage or after admission? What is this?
Admission stage, my lord.
The admission stage?
Yes.
So that has to be heard.
Well, it was already disposed by the Honorable Court.
No, I have seen the order of the Apex Court where the Apex Court has recorded the twin grounds on which the appeal was dismissed
Right.
and held that those grounds or the lapses cannot be attributed to the conduct of the appellate. And the fault of the court cannot prejudice any litigant. So the court set aside the order and directed this matter to be listed. So that's why I'm asking, it is at the admission stage or the appeal has already been admitted?
Understood.
Because
It is not admitted, my lord. If I'm permitted to say, it is not admitted. The questions of law have not been.
yes, substantial question of law has not been framed.
Yes, correct.
It has to be framed.
The main issue is covered by our own case for the earlier years of the Honorable High Court order, and also SLP was dismissed. That is, they have proposed the question of law at page 20.
Page 20.
Yes, my lord.
Yes.
Page 20, paragraph 16.
Yes.
Question number A, B, and C are on the same issue. That if I have purchased the goods and raw material from abroad, and the department's view is that I should have deducted TDS on that. Whereas this is a settled issue that the TDS is only required to be deducted if the income is chargeable to tax in India. And the matter is decided by Supreme Court in the case of GE India Technology. My friend will hand over the compilation I prepared for this, my lord.
Now this is stage of admission.
Yes.
So if we admit, then the question would be when we will fix the date for hearing of the appeal, because then he has to satisfy us on a substantial question of law, and you have to meet that question of law to be framed or framed by the court.
Yes, sir.
What?
But the question law in the page 20, paragraph 16.
So he has said that the earlier assessment here, they have accepted what the contention was the appellant want to raise. Is it your case?
Yes, earlier year 7, assessment year 7-8, in the first proceeding in the assessment, they have accepted this. Thereafter, 263 order was passed, again accepted by the tribunal and High Court and the Supreme Court. In this compilation, we have given all the orders.
Okay.
For assessment year 7.
Then in a subsequent financial year? Oh, they have accepted. The department has come. Yes.
Department of.
You are
What is-
respondent till now.
Oh, he is
law is not framed.
is not framed.
Right.
What you want to argue? Because we have to record whether this involves a substantial question of law or not. So you'll have to argue when. Are you ready?
No, my lord, 1 more time.
Why you are delaying?
No, but I got the file.
And this order of the Supreme Court was passed on 2nd May. How much time? Tell us.
Any day, my lord.
Any day includes today. So tell us when you want.
Fourth.
On the prayer of the counsel for the appellant, let this matter be listed on 4th. Mr. Kapoor, then you come on 4th, we are fixing this matter.
Fine, my lord.
Yes.
Sorry for the interference, my lord. Before your lordship rise, my lord, I mentioned in the morning, this matter may kindly be heard whenever, my lord, it's because 4 days, 30th, my lord, the reason for this urgency is one of the members retiring on 30th. The whole list is ready. For past 1 month, we have got the tribunal list ready. We are not able to release it only because of this situation, my lord, and it's committee headed by the sitting Supreme Court judge, Chief Secretary of Maharashtra, Revenue Secretary, Judge, President of the Tribunal, and all interviews.
What has happened? I am not aware what has happened in this matter.
Lord, what has happened is, Lord, originally a panel was constituted, and Lord went through the whole list, interviewed all the candidates, and Lord, the chairman of the panel, Lord, decided to opt out. So, Lord, opt out. Okay. So, Lord, a new chairman, a sitting Supreme Court judge was substituted. And because a new Supreme Court judge heard he wanted to interview the candidates again. So, 51 judicial members we did not interview because by that time the IB report came. IB report has clearly said 51 candidates, IB report has not been, it is adverse. So, this committee of 5 have passed an order. The minutes is there. I'm sharing the minutes in a sealed cover. These 51, not only this petitioner, 51 candidates who had adverse IB report, we have not invited. So we have put it in our counter. We have given it in the sealed cover also. So rest of the candidates have been invited, and my lord, the interview is over and the selection is complete. The list is also ready. Your lordship has said the selection process can go on, but list should not be released. And the list is ready from 30th May. And we can share.
Come ready. Who's for the appellant? Yeah, the red petitioner. So come ready at 2.
Yes, extremely obliged. Extremely obliged.
Come at 2.
Extremely obliged. Sorry for that.
Item number 38.
Supervision.
My lord. On totally harsh. And of the certain that it is not come to your office. I will ask Sophie for the I will have nothing. I finally done 23 your office and replicate and pass session. I thought that you never to record that session.
What is the matter about? I am unable to.
What has happened, my lord? Your office knows.
Because the ESG mentioned the matter, citing certain urgencies, so that it cannot wait till 30th. So that's why.
If your lordship permit, then your lordship will kindly see order number 1.
1.
Because the matter came up during the vacation.
Yes. Now, first you tell me what is the subject matter. Frankly speaking, I have not gone through the brief.
I'm just.
Please, in broad, in nutshell, please tell me.
Get it. What has happened? On the selection of the judicial member in this GST appellate tribunal, applications were invited. Petitioner is one of the candidates
Who applied his candidature.
my lord.
Correct.
Then thereafter, my lord, a search and selection committee was constituted. And then this petitioner, along with others, because the procedure also says about the shortlisting,
Yes.
he was called upon to attend the personal interaction.
Was called upon.
Yes, my lord.
Yes. Then.
And before the committee, my lord, he attended that.
Correct.
Thereafter, my lord, what has happened? What they say in the counter also, that one of the honorable sitting judge emitted from the office of that search and selection committee. So, another committee was constituted. The other committee, my lord, what has been done? Personal interaction was already over, and thereafter recommendations were to be made. But the other committee wanted that there should be a further interaction.
Okay.
In the further interaction, my lord, while calling the candidates who were shortlisted, petitioner was omitted. He was not called up.
Okay.
Altogether, 5 persons had attended that meeting at Kolkata, which was held earlier by the search and selection committee. And thereafter, my lord, 3 were called, 2 were omitted, including the petitioner. And the date for the next personal interaction was fixed to 31st of May. On 30th, the matter was taken up by this honorable court, where it was directed that the process may continue, but no final elections shall be made. This is the stage at which the petitioner had approached this honorable court.
Yes. Can I take, my lord, just 2 minutes?
No.
Sorry.
Yes.
Please go.
Yes.
What I humbly submit, my lord, this is a appointment to the post of judicial member of the tribunal, governed by a statutory rule. And that rule has been annexed to the writ petition as well as in the counter affidavit.
Yes.
If my lord will turn to that rule only, I will point out from the rule how there has been an infraction of the procedure.
Sure. Sure.
Your lordship may kindly come to page 27.
This you wanted is a hard copy is here with me. This notification of 15/2/2025 you are referring.
No, my lord, sir.
This is a rejoinder. Okay, this is a rejoinder.
That's in the rejoinder.
Yes. Hard copy da.
In the writ petition.
Hard copy is here. Yes. Give me a hard copy.
In the writ petition, your lordship gets the rule at
Page
17 it starts. The relevant portion of it will be at page 27. 27
Please.
with the heading chapter 2.
Yes.
Appointment of president and member.
Hmm.
There your lordship sees that selection for posts of president and members. Then 3(1). Committee may cause a vacancy.
No, these are the qualifications which are there. Number of the existing and anticipated vacancies, qualifications, salary, and all everything they have to give a details.
Yes, Lord.
So there is no difficulty in this regard because you have applied.
I applied.
Show us that.
I draw the lordship's attention to Rule 2.
Yes, the committee shall scrutinize or cause to be scrutinized.
Scrutinize every application received in response to the circular.
May shortlist such number of eligible candidates for personal interaction and it may deem fit.
No, I'm obliged.
Correct. Then
now what has happened, your lordship may kindly mark, may shortlist.
No, I understand. Such number of eligible persons for personal interactions.
No, this was done
by the committee.
Oh, in the earlier occasion, you just said that on earlier occasion, 5 members.
Yes.
I mean, the 5 persons were called, including you.
No.
But thereafter, the where is the searches, the search committee, selection committee? Which provision? That is what.
That will not be, that will be in the DBC, my lord. This is only qualification, and the manner of selection will be part of the DPC only.
This.
It was constituted with that constitution is that.
So they were the members.
Yes. That's at page 21 of my friend's writ petition.
Constitution is under section 110.
Below.
Yes.
100.
CGST or GST, whatever.
CGST.
Yes.
110. 110 also lays down the qualification. And on that basis, Rule 23 has been made. In the Rule 23, my lord, the qualification has been reiterated. So,
now where is the? I'm taken to 5th July 2024.
Correct.
Regarding the constitution of the committee. That was an earlier committee.
Yes. Yes. My lord is right. My lord is right.
Then what?
Second.
Where is the second committee?
Yes.
My lord, your lordship will
That
find
is at PDF page 23.
Page 80, my lord.
Oh, page. Okay. What?
Page 80. That is in the counter. That is on 24th of April 2025.
Where? Where do I get it?
That is at page 80. 80.
Joining page 80,
Next
another
page
page 19. NHRC.
Yes.
What I beg to canvass before my lord, that before going your lordship,
The chairperson for some reason does not
yes, lord.
continue.
Yes.
So the 24th April there was another committee.
Lord.
Correct.
And after this, what they said, your lordship may kindly turn to the counter affidavit. It is a very short counter affidavit.
Yes, I'm looking at counter affidavit.
Yes, Lord.
Lord, if your lordships come straight to our
your lordship may kindly come to page 63
of counter.
Yes, my lord.
Counter does not have page 63.
You are reading of
Internal page 2.
Running page. Internal page
2.
Yes. Refer paragraph.
This is in continuation to para 6, which your lordship may kindly see.
Okay.
1.
Yes.
In response to the vacancy circular, applications were received and a screening committee scrutinized the applications and eligible candidates were shortlisted for personal interaction.
Yes, we have seen. It was
Then
held on
personal
various dates at the multiple locations.
Yes.
So,
what is found from this, that a search and selection committee, which may itself cause the scrutiny, or the applications may be scrutinized by some authorized body, by the search and selection committee as per the language used in the statute. They shortlisted, and after the shortlisting was over, the personal interaction was held in which the petitioner had participated.
yes.
And thereafter, the next recourse will be sub-rule 4 of rule 3. That is about the recommendation.
Correct.
If for any reason at all, the search and selection committee has been reconstituted. Maybe that here in this case, somebody, honorable judge, had remitted from
demitted from the office. So it has been reconstituted. But my submission would be that it should have started from that stage, and if personal interaction can be done, so far as those candidates who were shortlisted, there is no reason to revisit. That is not provided for under the rules. If the shortlisting was already over by the search and selection committee, which was earlier a validly constituted committee, whatever action has been done by the search and selection committee earlier, that will hold good.
So according to you, that when the chairperson of the committee demitted or for some reasons does not intend to continue, then whatever the action which has already been taken by a search cum selection committee, the newly constituted search cum selection committee should start from that stage, and he cannot start a de novo the exercise. He cannot undertake a de novo exercise.
That is what my...
That is what your contention is.
And this, in fact, if your lordship will kindly see the rejoinder affidavit, I will only, because this will only have something persuasive value, because this has been done at Andhra Pradesh. Your lordship sees this notification where the Reconstituted...
It's not Andhra Pradesh, it is Karnataka.
Sorry.
Yes.
Karnataka. Here your lordship will see at the last page, the Reconstituted Search cum Selection Committee shall continue the work.
Yes, the same thing. From the stage in which the earlier committee left.
No. This is only I wanted to draw that. Well, and after all, these interpretations which have to be done, that is the scope of judicial review. Your lordship can hold that the search and selection committee, whatever action has been done by the earlier one, because it is in a perpetuity, the next committee is to proceed from that stage. And if nothing otherwise has been provided under the rules, there is no occasion for them to revisit.
Yes.
May I please, Your Lord?
Personal interaction should have been, might have been that because
it is according to you, it is indispensable. They have to do it. They cannot go back or pick and choose. They cannot do. That is what your contention. No. Your contention is straight away that the reconstitution of the search and selection committee does not mean the de novo exercise to be undertaken by the reconstituted committee, but the reconstituted committee should continue from the stage when the earlier committee left, where the earlier committee left, and thereafter this is to be done. So according to you, you should have been called again for interaction.
Yeah.
That's your case.
That's it.
Well, personal interaction, I will just put one sentence more. If at all the personal interaction which has been done, but on the basis of the personal interaction, the final recommendation has not been done, or the report has not been signed. As your lordship finds in most of the occasions, whenever the case is heard before a particular bench and the judgment is not delivered, whenever it goes to the other bench, the matter will be again heard. For that reason,
that is a difference because it is a de novo, because that is a different aspect.
No, I leave it to your
hearing in a judicial side is a different aspect. You can't bring those notions here.
I was just considering to the extent that they are to call all candidates for personal interaction. They may call, even if personal interaction was held earlier. But there cannot be any omission. So far as shortlisting is done, that is the final thing which had been done by the earlier search and selection committee.
Yes. I got you.
My Lord.
Yes.
Only two submissions.
Yes.
Lord.
Yes, sir.
Yes. My lords may note 3 dates. Lord, the first date is which your lordship saw, page 21, Annexure B, 5/7/2024 is the first committee.
Annexure B2, your counter or?
I think their petition, Lord.
Their petition.
Page 21.
Page 21 is what?
57/2024 is the search first committee. Mr. Prasanna, can you?
That is the 5th July 2024.
Yes, yes, that's the first committee.
Yes.
But this committee, my friend is right, invited all the eligible candidates at that point of time for an interaction. It's a
Correct.
fact which my friend is right, I agree. At which point of time, we didn't receive the IB report. So, my lord, based on 3-1 qualification, 3-2 process took place. Rule 3-1 had the qualifications, and Rule 3-2, my lord, said, as deemed fit, you can have a personal interaction. So we invited all the eligible candidates for an interaction. The first committee interacted with them. This is the position. Then, as my lords very rightly observed, the chairman, because we were told that he has to take some other assignment immediately, he demitted office in this. So the second committee was constituted, page 23, Annexure C.
Next page.
Next page.
I have seen that. Yes, 24th April.
My lord is right. My lord, in both the cases, the chairman or my lord is sitting judge of the Honorable Supreme Court. So, my lord, the learned judge, it may be fair to say you continue from there, no difficulty. We have not restarted the process. We're only continuing the process. And how? The learned chairman, my lord, said, before we announce the declared candidates, he would like to have a personal interaction because he's coming for the first time. So, my lord, it was the desire of the second committee to have a further personal interaction, which is also a fact. The only difference between the first interaction and the second interaction is, my lords may see the sealed cover. We have now got on record the minutes of the committee. The minutes of the committee. The chairman and all the 4 members have signed the minutes. My lords may, I don't want to read it in the virtual court. My lords may see paragraph 6 of the minutes. Paragraph 3, subpara 6.
Just a minute.
Yeah, I'll wait. No, let their lordships speak. I don't want to read it being a classified document. My lords may kindly permit, lordship may kindly see it.
No. You need not have.
Yes, deeply obliged, my lord. Para 3, subclause 6. Yes. My lord saw that. Yes. My lord saw 3-6. Now, Lord, please see the such committee's list of names that your lordship will find in the next document, serial number 17, page 3, annexure 3, serial number 17. The writ petitioner's name figures there. serial number 17.
Yes.
And we have not, yes. And my lord, totally there are 51 such candidates. We have not discriminated any. We have not invited all the 51 for further interaction. My lord, if your lordship sees the minutes, you use the word further interaction. It's a continuum. It uses the word further interaction. Please see para 3.6, last word. Not considered for further personal interaction. That's the language used in the minutes also. It's a continuum. There's no discontinuity. Because the report came, it facilitated us who should be called for further interaction. Number one, the legal position is fairly settled. I'll place 2 judgments, my lord, and close the case. 3 important legal principles are involved. One, my lord, merely because a candidate is an eligible candidate, he doesn't get the enforceable right for an appointment. I'll show the judgment for that. This is principle number 1. Principle number 2 is, my lord, IB report is a real facility, and if there are adverse remarks, my lord, then the committee has to act upon it, which is exactly what it has done, your lordships of para 3.6. Therefore, there's an application of mind by the committee for your lordship's satisfaction that the IB report has been factored. And 3, my lord, it also very clearly says, Supreme Court very clearly says, especially when a constitutional authority is heading a committee, the wisdom of the constitutional authority is not amenable to judicial review. Either the IB report or the wisdom of a committee headed by a constitutional authority cannot be amenable to a jurisdiction or amenable to, my lord, these reliefs will ultimately, my lord, destabilize the system of the election process. And therefore, the court 2 judgments, my lord. One is, my lord, 2006, one SCC 779.
Just 1 minute.
Yes, ma'am. Will your lordship see plot 2006 1 SCC 779? My lord, it is totally 6 paragraphs. I'll just read 2, my lord, for the sake of time. Paragraph 13 to 19 are relevant. My lords may come directly to para 40. May I read that, my lord? Unfortunately, the High Court seems to have proceeded on the footing that the appointment was being made on its own by the central government, and there was an irregular procedure followed by the secretary by giving undue importance to the IB report. It was most irregular on the part of the High Court to have sat in appeal over issues raised in the IB report and attempted to disprove it by taking affidavits and oral statements of Advocate General at the bar. We strongly disapprove of such an action on the part of the High Court, particularly when it was pointed out to the High Court that all along with the proposals made by the government, the Minister of State has specifically directed for submission of IB report to the Chief Justice of India for seeking his concurrence, and this was done. We note with regret that High Court virtually sat in appeal not only over the decision taken by the Government of India, but also over the decision taken by the Chief Justice of India, which is discarded by a side wind. In our view, the High Court seriously erred in doing so. Even assuming that the Secretary of Department concerned with the Government of India has not upright himself of all the necessary facts, one cannot assume or impute a high constitutional authority like the Chief Justice of India such procedural or substantive error. The argument made at the bar, the Chief Justice of India might not have been supplied with necessary inputs, has no merit. If Parliament has reposed faith in Chief Justice of India as the better families of the judicial hierarchy in this country, it is not open for anyone to contend that the Chief Justice of India might have given his concurrence without application of mind or without calling for necessary.
I understand. The principles which is there is that was in relation to the appointment of a member in the Central Administrative Tribunal. And the rule which is applicable is that these appointments have to be made in consultation with the Chief Justice of India. And now, when a Chief Justice of India has opined and is given his opinion, then primacy has to be given, because it can't be said that he is not aware of any the consequences or the nuances that is applicable in this regard.
And why
if he has accepted the IB report, then also that some credence or some thing is to be attached to it. That was a case because of the All India judges cases where the Supreme Court, in consultation, everything that was given. The question here, which really posed by them, is that whether the reconstituted committee can start a de novo exercise when an earlier exercise has already been done by the earlier committee. That is the only point.
Yes, the answer is, I'll answer it in two parts. If they have proceeded to issue an appointment for any reason, then it will be prone to a challenge to say there's a substitution and a chairman in the capacity of a Supreme Court sitting judge is coming there. And even without knowing who the candidates are, he has allowed it. That will be the case. So, the learned judge was very specific that I want to interact. And he interacted with all the judicial members who were eligible and who did not have an adversary. We did not miss out any. We have done two things very clearly.
No, there is no difficulty. I tell you, what I find is that the provisions of law, that the Section 3(4),
yes,
which has now been placed,
yes,
and relied by all the parties. I think you are also relying, they are also relying, and interpretation is sought.
Yes.
Question is that when an earlier committee have scrutinized the entire documents,
yes,
and then eligibility was found or ascertained, and then the interaction is inevitable because the law mandates that interaction is to be done.
3-2, correct.
And thereafter called for interactions. In the event, the chairman demits the office for whatever the personal reasons are there, and it's reconstituted. Then in that event, the only question arises that a reconstituted committee can exercise the entire things de novo from the scratch to the end, or he is liable or he is mandated to continue from a stage of the selection process left by the earlier committee.
The two answers are twofold.
So interaction is inevitable. There cannot be a dispensation or I would say whittling down of that provision, because there is some mandate of the law that you should interact with the candidates. Suitability is within the wisdom of the committee.
Correct.
One can be found eligible, another may not. That's the wisdom. Nobody can impinge upon that the wisdom was not proper.
Absolutely.
The only thing is an opportunity. We are conscious that mere selecting a person for a further tier of the recruitment process or including within the panel which is prepared of a successful candidate does not confer any indivisible right or an inchoate right to appointment.
Absolutely. Para 15,
It's absolutely a settled proposition of law. Nobody can dispute on that.
Deeply obliged. Para 15, 16 are the same judgment.
Right to appointment and right to be considered for appointment are two facets.
Absolutely. Beautiful plot. Beautiful learning. It's a great learning. Absolutely plot. Condescend to your lordship's my lord.
He wanted my right to be considered. Please consider that. Appointment, I can't claim that I should be appointed.
And therefore, the answer is this. But how did they come? When the first committee decided to interact, it did not have the benefit of the IB report at that point.
Yes.
Now, suppose they had it and they chose to still invite and we have not done it, my friend may have a case. Yes. We didn't have the benefit. And Lord, please see what the report very clearly says, para 6.
No, I have seen. I have seen the report. You did not have to reiterate it.
Yes. And Lord, please see the mandate, as your lordship saw, mandate of Rule 232 read with Rule 34. My friend read Rule 32, no doubt about it. And please see Rule 34. One of the criteria is what is found in paragraph 6 as failing in these 51 candidates.
Yes.
That's all, my lord. Therefore, there's no need for a case law. I just gave it for, my lord, for the sheer chance I got an opportunity to persuade, my lord, a legal issue proposition, 3 propositions. And, my lord, what your lordship saw, this precisely is para 15 and 16 in the very same judgment. They follow the Jharkhand High Court, Supreme Court endorses the view of the Jharkhand High Court, the same judgment. What your lordship fell from your lordship last, same concept is there in the judgment of the Supreme Court itself. In this matter, the approach adopted by the Jharkhand High Court comments to us. The Jharkhand High Court approached the matter on the principle that judicial review is not available in such matter. The Jharkhand High Court also rightly pointed out mere inclusion of a candidate's name in the selection list gave him no right. And if there are no right, there would be no occasion to maintain a writ petition for enforcement of a non-existing right. Therefore, this is how the 2 points.
No doubt about it. It's a more fundamental principles than.
And this 2006 judgment is reiterated in Delhi High Court Division Bench 2018. SLP against this is also dismissed. We'll give that copy also. So all that we are now requiring your lordship is, if a lordship comes to the second list, the second committee, which is at page 23, issued on 24th April 2025. The third serial number, Chief Secretary, Government of Maharashtra, is demitting office on the 30th June. Everything is over. The election process is complete, my lord, on 30th May. It is pending for the past 26 days. And my lord, page 23, my lord, the second selection committee constituted on 24/5/2025. Serial number 3, Chief Secretary, Government of Maharashtra, is demitting office on 30th of June.
Yes.
And therefore, my lord, the urgency which I'm so sorry, my lord, we had to put extremely I'm grateful to this court's indulgence. My lord, lordship may kindly dispose of the writ petition itself as, my lord, not an enforceable right. And we may be allowed.
You are relying on a Delhi judgment, which in fact can be perceived as a judgment of this court.
Written by your lordship is there. 1 minute. I didn't see it, my lord. So sorry.
Supreme Court apparently sent the choice.
Okay, deeply obliged, my lord. And the SLP also stands dismissed.
The author of the judgment was the Chief Justice of this court.
This court, yes, this is only. A very highly respected learned judge of this. Lord, we may be allowed to proceed with them.
Yes.
Anything
in reply?
You reply in 2 minutes. My document has relied on that judgment of 2006, 1 SCC 779, which really dealt with a case of a constitutional appointment. Here we are concerned with a statutory appointment under the statutory rules. And furthermore,
what constitutional appointment? It is under the Administrative Tribunals Act, which is there. That's the case comes under the Administrative Tribunals Act.
Tribunals.
When a member of the Administrative Tribunal is appointed, it comes under that act, not the Constitution. And all the laws or the statutes are subservient of the Constitution, which is the paramount law.
That's true.
It has to, all the act has to withstand on the parameters of the constitutional provision. Otherwise, the virus is always.
Yeah. Offspring has to come from the mother. The offspring of law has to come from the mother document constitution. My lord is right.
Administrative tribunal is, my lord, constituted under the constitution. That's the case.
No, you are talking about Article 323A and 323B. I am conscious of that, but
I know, my lord.
But the recruitment or the process of selections are guided by the act itself, that how it has to be
And
done.
there, my lord, what is there involved in that case? It was for the government to consider the IB report, and the government is the authority to appoint. Whereas search and selection committee, my lord, it proceeds with a personal interaction and recommends the name of two persons to the government, and the government is the appointing authority, not the search and selection committee.
No, it's a recommendation.
Yes, my lord.
Oh, that is why he says, the judgment also says, then in consultation with, say the designation is given. It's really a designation or a post which is given in administrative tribunal. So in all India judges cases, the in consultation with has been extensively dealt with. What does it mean? Mere a farcical exercise, or it's a mandate which is to be considered? So that is a constitution means decision, sit at rest. Mandate, you can't.
I'm not supposed to know about this IB report.
No,
but what my
that's absolutely a privilege
that is
and the internal
I'm not
communication.
supposed to know. But what my humble submission would be that it is for the government to take into account after the personal interaction, because that is for the appointing authority to consider.
No, only thing that is what that troubles, because you have also said that the screw. Now question is that there are two sections which are there. One is section 3(2). No, 3(1).
3(1).
And
yes, ma'am. 3(1).
Yes, 3(1). Then the 3(2).
Yes.
And then the 3(4) will come.
Yes.
So now, whether the reconstituted committee can start de novo from 3(1) as well.
I'm very, very obliged. That interpretation is the domain of the court.
Or 3(4). Lord, what cannot be recommended? It will be a fait accompli. What the committee cannot recommend, it will be a farcical exercise to call 51 people. My friend, senior friend, my lord, wants. We should have gone to Calcutta one more time.
It has not reached to the state of recommendations. If it is not, it is a recommendations. Yeah, that's true.
Yes.
Things must be done in the way prescribed.
Well, I'm happy, my lord. My friend articulated a point. Give me 1 minute. It's a pleasure to address this court. One last sentence, Balot. One last sentence, my friend. Please see 3(4), Balot. It's the language of 3(4). Very interesting. The committee shall make its recommendation based on the overall assessment of eligible candidates, including
difficulty that Mr. ASG would be if 3(4) is to be considered, then at what stage it has to be taken into account will come.
Yes. Well, it is not that. Well, may I put it this way.
No, what you are saying is no doubt, because it is imperative for the search and selection committee to take into account every aspect of it.
Yes.
And one of the aspect is also there. I do not want to mention it. I know it.
Yes, yes.
So in that event, there is a different.
Yes, my lord, it becomes a fait accompli. Other than, my lord, visiting the committee and flying one more time to Calcutta to please my friend's client, nothing else would have happened in this case. It's a pleasure. It was a great indulgence show. It's a pleasure to address this court. Pleasure to address this court.
The matter is taken up out of turn on the prayer of the parties, citing an urgency as one of the member of the search and selection committee constituted under the act constituted
Section 10,
under the goods and service tax appellate tribunal within bracket appointment and condition of service of president and members bracket close rules 2023 is likely to demit office on and from the 30th of June 2025. Stop. An application for vacation modifications and or recalling of the order dated 30th May 2025 is taken out. Semicolon. In addition thereto, the counter affidavits are also, the pleadings are also exchanged by the parties so that the court may in the event intended to hear the matter finally, the same may be taken into consideration. So, it is undisputed that the petitioner offered his candidature pursuant to the advertisement issued by the concerned authority for the appointment of the member in the GST appellate tribunal to be constituted under the GST Act, and search and selection committee was constituted, consisting of 5 members. How many?
Yes, 5 members. 5 members headed by a lot of sitting judges. Yes.
Consisting of 5 members,
Including this sitting judge.
under the which includes the chairman, who would be the judge of a Supreme Court. There is no dispute on the composition of the search and selection committee, nor on the procedures followed in constituting such committee, but the dispute hovers around the action of the search and selection committee on the premise of the violation of the statutory provisions, stop. The entire arguments advanced by the respective parties are founded upon the applicability and the interpretation of Rule 3 of the said rules, which postulate the which postulates exhaustive mechanism for conducting and appointing the member of the said appellate tribunal. Full stop. It would be opposite to court rule 3 of the said rules, which runs thus. The conjoint reading of the various conjoint reading of the language employed in the aforementioned rule leaves no ambiguity that the committee so constituted may cause a vacancy circular to be issued inviting the applications from the intending candidates who are mandatorily required to furnish the criterions appearing in subrule, the various clauses of subrule 1 thereof. The committee is further after the receipt of the application from the intending the candidates, the committee is obligated to scrutinize or cause to be scrutinized each and every application so received and shall shortlist such number of eligible candidates for personal instruction as it may deem fit. Precisely, the arguments are advanced by the respective parties on the interpretation and the manner of the applicability of the aforesaid provisions in juxtaposition with the action of the search and selection committee. Stop. It is no doubt true that the search and selection committee constituted on 5th July 2024 after exhausting the procedures as mandated in rule 3 of the said rules, selected the candidates for personal interaction, and the petitioner was included as one of the candidates, and in fact appeared for personal interaction. The said committee was reconstituted on 24th April 2025 as the chairperson of the earlier constituted committee showed his inability to continue in such capacity. Capacity. Full stop. The reconstituted committee as the tenet of the said office memorandum dated 24th April 2025 suggests, scrutinized the applications, invited the feedback or the opinion from the Intelligence Bureau, and selected the candidates for personal interaction. Since the petitioner was kept outside the zone of the said personal interaction by the subsequent reconstituted committee, the approach is made to this court on a solitary premise that the reconstituted committee cannot adopt a de novo exercise, but should continue from the stage at which the said recruitment process was left by the earlier committee. Next one. A piquant situation has arisen in the instant case, more particularly on interpretation of the interpretation of Rule 3 of the said rules, and the said rules, which does not contain any express words or stipulation in this regard. The rule does not, in express words, suggest the procedures to be adopted by a reconstituted search and selection committee. And therefore, it invites a solemn duty of the court to interpret the said provision interpret the said provisions in a pragmatic manner. It is no longer res integra that the interpretative tools in relation to the statutory provisions is used with an avowed object of upholding the intention of the makers of the law and to make such provision workable as opposed to rendering the said provision ocious or redundant. The harmonious interpretation of the various provisions should be strictly adhered to, more particularly on the basis of the object and purpose for which the said legislature is put in place. Rule 3 within bracket 1 of the said rules is a repository of the information to be furnished by the intending candidates so as to bring an uniformity in scrutinizing the applications. And a prescribed form is also appended thereto. Sub-rule 2 of Rule 3 provides for personal interaction after the scrutiny of the applications by the committee. Of the shortlisted candidates. Sub-rule 4 of Rule 3 though apply at a particular stage, yet imbibe within itself several aspects to be borne in mind before the committee recommended the name of the candidate to be appointed as a member. There is no quarrel to the proposition of law that mayor offering the candidature in a public employment does not create indefensible or inchoate right into the appointment. Even a person whose name is included in the select lists also cannot claim a vested right on appointment. It is within the prerogative of the committee or the appointing authorities to appoint a person to a post subject to the fulfillment of the various criterions envisaged from the statutory provisions. As discussed herein before, the provisions contained in Rules 3 does not in express term postulate the role of the reconstituted committee or the procedures to be adopted by it in the event the earlier committee could not, in the event the one or more member of the earlier committee signifies their intention to demit the office. The expression within courts as it may deem fit has to be construed in a more pragmatic manner and to be ascribed the meaning in a reasonable way. Stop. Such expressions cannot put an unfetter put a deterrence to the action to be taken by the statutory committee, nor the restrictive interpretation should be assigned to whittle down the object of constituting the search and selection committee. So the court cannot overlook that the selection to such an important post, which requires a high degree of an integrity, the knowledge and or the experience, as such post ordains the solemn duty of adjudication of the rights of the rival parties. Within the framework of the statute as well as the constitutional provisions. The suitability and integrity is the hallmark of in any judicial in any appointment in a court or the tribunal, and therefore a synergy is required to be created amongst the various clauses or the sub-rules appearing in Rule 3 of the said rule. The committee comprises of the high degree of the persons holding an high degree in a constitutional scheme, and therefore the action has to be tested on the anvil of keeping the same in the mind. The Apex Court in Union of India and others versus Kalidas Batis and another observed that once the constitutional authority have accepted the report submitted by the IB and did not find the candidate to be suitable to hold a highly responsible post, there is no justification in discarding such opinions expressed by the constitutional authority in the following paragraph 14 and 15 to be quoted from this judgment. The authority has to act within the precincts of the provisions of the law, and in the event there is no fetter put in the authority, if this reconstituted search and selection committee decided to start the process de novo, we do not find any statutory obstacle having put in this regard. We have been taken to confidential reports received by the committee which cannot be said to be a mere piece of paper. And if the selection, the search and selection committee decided to undertake an exercise of scrutinizing the applications and selecting the persons for the personal interaction on the basis of the inputs received from the Intelligence Bureau, we do not find that there can be any illegality perceived from the action of the authority as the selection committees. We therefore do not find any merit in the instant writ petition. Dismiss, no order as to cost. This is resealed and give it back to them.
I'm extremely obliged for this intelligence. It's a pleasure to have addressed this honorable court. It's a great learning for us. Great learning. We'll be able to take the order copy tomorrow. That's a request.
It is already pronounced in the open court. There is no difficulty.
More than it.
The difficulty is because of a very, very festive mood which we are all.
Yeah.
So that is what is important.
Again, my lord will go. Happy.
Yes, thank you.